So Colorado eviction laws vary from county to county in terms of court proceedings and fees, but despite that, they all follow the same general eviction process. You send out a clear written notice, you fill out the forms, you serve the tenant, you attend the trial, and then you wait for judgment. But every eviction process is different and completely dependent on the lease agreement that was signed by the tenant and the landlord. So it's always best to exercise meticulous file keeping to avoid errors that the tenant could then exploit. So I'm going to give you a detailed summary of the eviction process that you can refer to when evicting a tenant, but remember that I am not an attorney and this is not legal advice. Nothing can replace asking an attorney in your area for legal advice with your specific case. Now, rent is usually considered late a day past its due date, but a grace period may be available if stated in the lease or rental agreement. And before the landlord can start the eviction process, they must give the tenant an official written notice to pay. This is also known as a demand for compliance. The amount of time landlords give their tenants to pay depends on their tenancy, and if the tenant pays the rent within the notice period, then the eviction process does not continue. But if the tenant is unable to pay, the landlord may proceed with the eviction process. So the rental agreement has to be upheld by both the tenant and the landlord for the entire duration of the tenant's stay. And yes, agreements may vary from tenant to tenant, but these must be clearly stated within the lease. If the tenant violates any terms from the agreement, the landlord must issue a written notice to comply, informing the tenant of their violation and specify how long they have to comply. Now, the length of time a tenant has to resolve the issue or leave the premises kind of depends on their tenancy. But if the tenant resolves the issues on time, the eviction process does not continue. Lease violations may include damaging the property, keeping pets in pet-free zones, staying longer than indicated on the lease, or surpassing the maximum number of allowed residents within the rental property. If the tenant fails to resolve the violations on time, then the landlord may continue with the eviction. Now, if a tenant has engaged in illegal behavior within the property, the landlord must issue a 3-day notice to vacate. What kind of illegal activities? Well, I'm glad you asked. This includes things like involvement in the creation, distribution, or consumption of illegal drugs, assaulting anyone on or near the rental property, conviction of any criminal act that carries at least a 180-day penalty, or theft, violence, and assault. Clients charged with this type of violation do not have the option to correct it. They have to move out before the notice period ends. If they continue to stay on the premises, then the landlord can continue with the eviction process. So in Colorado, landlords cannot evict tenants or force them to vacate the property without probable cause. As long as the tenant doesn't violate any rules, they can stay there until their rental period ends. But if the tenant stays on that property even a day after the agreement ends and has not arranged for a renewal, then landlords can issue a notice to quit. Additionally, landlords are not obliged to remind their tenants to renew unless it is stated in the original lease or rental agreement. The length of time a tenant receives before vacating the property depends on the duration of their lease or rental agreement. The eviction process can only begin after the issuance of the notice to vacate, and the landlord must have allowed enough time to pass before filing for eviction. But the general eviction process is as follows. First, you're going to proceed to the county court that the rental property belongs to. Next, you will file the necessary documents. Third, you will pay the fees. In Colorado, filing fees start between $85 and $135, really just depending on the type of eviction. So where are we at in the timeline? Well, it takes anywhere from 1 to 91 days from the notice to pay or quit issuance, depending on the reason for eviction and the lease agreement, before a legal complaint may be filed. So before filing for an eviction with the court, you need to issue the tenant a notice to comply. If you check out our website, we have a free PDF or Word template, or you can use the step-by-step wizard that guides you through the entire process, and this just makes sure that you are submitting the legally correct notice. Now, the step-by-step wizard will ask you to pay a small fee at the end, but to me, that's a small price to pay to ensure legal compliance and protection. I mean, how embarrassing would it be if you got there and you realized you did the very first step of the process incorrect? So a copy of the summons and complaint is then served to the tenant. It must be served at least 7 days before the hearing. Now, there are several methods you can use to accomplish this. You can use a personal service where a copy of the summons and complaint is delivered to the tenant in person, or, if they're unavailable, you can use what's called a substituted service, in which case a family member who is over the age of 18 may receive the documents. Now, if neither of these options are available, a copy can be left at the tenant's workplace. And then there's the posting method, in which case the server leaves a copy of the documents in a secure, visible place by the entrance of the property. Just remember that when using the posting method, the server has the additional responsibility of mailing the documents via first-class mail. As well, landlords are not allowed to serve these documents to the tenants themselves. They have to ask someone uninvolved in the case to do it for them. The person tasked with serving the documents may be someone from the sheriff's office or a personal process server. Just keep in mind that additional service charges may be added for either option. However, if you decide to go with someone else, just remember they have to be uninvolved with the case, they need to know the service rules, and be at least 18 years old. So the tenant then has 7 days to prepare for the hearing. Now, a written answer is not required from the tenant, but they must be present on the day of the hearing. Failure to do so may result in the judge ruling in favor of the landlord, regardless of the tenant's attendance at the hearing. So at this point in the timeline, the eviction hearing is scheduled, and it's scheduled for 7 to 14 days after the complaint is filed. And again, remember that the documents should be served to the tenant at least 7 days before the hearing itself is scheduled. So, if you provide a strong argument backed with solid evidence, or if the tenant just doesn't show up to the hearing and you win by default, then the eviction process continues. So, once again, in the state of Colorado, a reply from the tenant is not necessary for the court date to be scheduled. They only need to provide a written answer or counterclaim on or before the eviction hearing. Additionally, the judge could also require that the tenant and landlord attend a mediation session with a trained mediator before either hearing. If an agreement is not reached, then the responsibility of providing evidence falls on the landlord. You would then need to gather the evidence to support your claim and show it during the hearing. This includes but is not limited to things like a copy of the deed and the lease, receipts and ledgers, bank statements, witnesses, or photo and video documentation of the violations and correspondences. However, a follow-up hearing will be scheduled to continue discussing the case if the tenant files a written answer. So timeline. At this point, it's been 7 to 14 days from the filing of the complaint, and if the landlord filed all the proper documents and provided a legal reason for the eviction, a summary of judgment can be given in the landlord's favor. After the landlord wins the case, provided the tenant does not appeal for a reconsideration, a writ of restitution is issued at least 48 hours after the landlord wins the case. The tenant then has a maximum of 48 hours to vacate the property. If they are still on the property after 48 hours, they may be forcibly removed. So like I said, the tenant receives 48 hours to leave the premises with all of their belongings. If they remain on the property, the landlord can schedule a time for eviction with the county sheriff. Just remember that the landlord is not allowed to force the tenant to move out. Only authority from the sheriff's department is permitted to do so. If the tenant leaves behind any belongings due to the forcible eviction, then the landlord must contact the tenant and give them 15 days to retrieve their belongings. However, if the tenant left the belongings voluntarily, the landlord must wait 30 days before disposing of the items or placing them in storage. So from the time the landlord wins the case, the tenant has 48 hours to move out of the property. If the tenant is still on the property by the end of those 48 hours, they have until the landlord schedules the time for eviction to move out. This could take a few hours or a few days, really just depending on the availability of the landlord. So, here's the average timeline for a complete eviction process. Just keep in mind that this timeline can change depending on the complexities of the case, like if there's a second hearing. But all in all, on average, it takes anywhere from 10 to 107 days to complete the eviction process, and please remember, you are not allowed to be the one to evict the tenant by force. Leave that job to the authorized officials. So if the tenant disagrees with the eviction request and they do reply to the court, it is crucial that you keep extremely good records of everything so you can provide proof to the judge and win your case. So how can you stay organized? Well, you could keep a physical paper trail, but this gets hard to search through and takes up a lot of storage, plus things could easily get lost or damaged. So the next step I would say is get a scanner. You can find a great scanner for $300 to $400, just scan everything right into your computer, and then once you have done that, store and back up everything using things like Dropbox, Google Drive, or OneDrive. Really any easily searchable option. Or if you really want to make it easy for yourself, just use a property management software. You can use these to save everything from lease agreements to signed documents, violations, notices, invoices, payments, reminders, pictures, videos, anything you can imagine. This is a great way to store all of your proof in one place to bring it to court. Now, if the tenant doesn't pay rent and they dispute that claim, it's important that you show the judge the following. Show them your lease agreement, your terms of the agreement, and when the rent is due. Additionally, show them any penalties for a late payment. Show them all payments, all the previous payments, how they were made, and the date they were normally made on. Show them if there were any payment returns. Show them any checks that bounced, any times the bank account had insufficient funds, or they did a chargeback dispute on their credit card. And if this has caused you to get any fees from your bank, show that to the judgment too. Additionally, you can show any fees that your bank charged you and any penalties that are owed according to the lease agreement. Additionally, show them all of your messages. If you send automated or manual payment reminders, it's essential to show this, because while it's not really needed, it's still good to show that they were aware of the situation and they were given time to cure and make a payment. This is why it's generally best to have everything in writing instead of just doing phone calls or face-to-face meetings, because in these situations, you really need that to back up your case. Now, if you're evicting the tenant for lease violations like unauthorized pets or property damages, it's important to show proof of that too. You can use things like security cameras. If you have a surveillance system, just show them committing the crime or lease violation. It's pretty safe to say that if you have this video evidence, you're gonna win the dispute. But if you miss them in the act, the next best thing you can do is take out your phone and record a video of any damages or violations that you can find. Additionally, be sure to take pictures. Even if you already took a video, show the pictures to the judge too, and this also makes it easier to see by email or when it's printed out. No, a landlord can actually be sued for a forcible eviction of a tenant if they skip the proper process. In the state of Colorado, tenants can actually sue their landlord for damages in cases like this, so don't do it. Self-help eviction is illegal. What constitutes as a self-help eviction? Well, I'm glad you asked. This includes but is not limited to things like cutting off electric, water, and heat, changing locks to prevent the tenant from entering the property, or vandalizing or destroying the tenant's property. Thank you so much for watching this video. I hope this helped clarify this process for you. Be sure to check out this playlist where we go over a bunch of other landlord-tenant laws that are important for you to know. Subscribe if you haven't already. Thank you so much for watching, and I will see you in the next one.